Hi, I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning technology and intellectual property law firm that also passionately litigates in these areas of practice. In this video, I'll discuss the legal test that the court uses to determine whether or not there has been infringement of copyright in computer code. This involves what's called the test for substantial reproduction, and it may actually surprise you as to what's involved. So in this video, I'll discuss how copyright subsists in computer code, the legal test for substantial reproduction, and the evidence the court needs to determine whether in fact a substantial reproduction has occurred. So how does copyright subsist in computer code? In Australia, Section 32 of the Copyright Act, 1968, provides copyright protection for original works. Pursuant to Section 10(1) of that same Act, literary works includes computer programs. The same section defines computer programs as a set of statements or instructions to be used directly or indirectly in a computer to bring about a certain result. So there is a clear definition. Section 36 of the Copyright Act states that a breach of copyright for literary works, including computer code, occurs where the work is reproduced in a material form. So material form is defined in Section 10 of the Act as a substantial part of the work, therefore lowering the threshold for reproduction as it does not require an identical reproduction. It's a bit of an urban myth that you can copy something and perhaps use it or change it by 20% and get away with it. Well, that's just a myth. There is no sort of defining percentage. So the test for substantial reproduction of computer code. This test was considered in the case of Data Access and PowerFlex in 1999 by the High Court of Australia. In that case, the High Court stressed that in determining whether something is a reproduction of a substantial part of a computer program, the essential material features should be ascertained by considering the originality of the part allegedly taken. In other words, essentially, when determining if a substantial reproduction of a computer program, it's necessary to examine what was allegedly taken and compare this with the original. This is much more than a side-by-side comparison, although this will necessarily be involved. In matters involving literary works or artistic works, it's a side-by-side comparison. So the test for copyright infringement is contained in the case of ICE-TV Proprietary Limited and 9 Networks Australia in 2009 by the High Court, where the court expressed the need for some process of qualitative abstraction of the material features of the computer program in question in order to determine substantiability. So in the case of JR Consulting against Drafting Proprietary Limited and Cummings, the Fourth Court of the Federal Court expanded the test for substantial reproduction to conclude the consideration of the quality of the work alleged to have been reproduced. The consideration of quality relates to the originality of the work reproduced. Simply because a part reproduced originates from the author of that part, it does not mean that it is a substantial part of the whole work. This is because when assessing the quality of the part taken, it may be there has been a reproduction of something largely unoriginal. Now just think about this for a moment. But you've copied something, but it might be that something is not quite original. And this is particularly the case where you've got open source code involved. So the emphasis here is on the qualitative rather than the quantitative assessment of substantiality. Even if the piece of the reproduced code may be small in proportion to the total size, the quality of the code of the code copied will be considered over the quantity. So in the case of CA Inc. against ISI Proprietary Limited in 2012, the Federal Court again stressed the need for a qualitative assessment and further elaborated it to involve a consideration of the functionality, while a quantitative assessment involves consideration of textual similarity, thus drawing a bit of a distinction. Justice Bennett said in this case that the evidence may be required of the company's usual activities in order to understand the significance of the allegedly copied code. Otherwise, a qualitative assessment of a substantial part could not be performed by the court. So this leads us on to the last point of this video, which is what evidence might the court require. So when considering what is alleged to have been copied in computer works, the applicant needs to provide a complete description of the technology involved. We call this the technology stack. The source code that is alleged to have been taken needs to be identified with precision. An applicant must then establish that the work is original and that it is the owner of the software in question. That involves necessarily tracing the chain of custody of the intellectual property in the code. The applicant then needs to describe the precise functionality of its software and the purpose or function of each element that has been allegedly copied. This is so the court can make its qualitative assessment. Briefing the requisite expert is critical in this regard. So in short, side-by-side comparison is important. However, it may not be sufficient in order for the court to make its assessment of qualitative features. So to summarise, determining whether there has been a substantial reproduction in the case of computer code will involve both considerations of qualitative and quantitative elements. Ultimately, the court will consider the essential or material features of the work being produced with a view to a qualitative test of substantiality. This means that even the use of a single code library can be enough to substantiate a substantial reproduction of a computer program and to be sufficient to amount to copyright infringement, provided, of course, that the part being copied meets the quality test. So if you're looking for a technology-savvy law firm to advise on a litigious matter involving copyright infringement in computer code, or you have a dispute regarding a software development project, please don't hesitate to call me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching. Video adjourned.